Well, as many of you know, we like to keep you updated on the latest methods of surveillance the government is taking, since it's a topic a whole lot of other media outlets don't bother to discuss at all. Well, there are a few new developments out there. First, the U.S. Justice Department argued in court yesterday that authorities should be able to get their hands on minute-by-minute movements of cell phone users over a 60-day period without having to ask a judge to approve a warrant first. Second, out of concern for such actions like this, the California state legislature passed a bill stating that law enforcement agents and other entities would be required to obtain a valid search warrant in order to access location-specific information submitted or received by electronic devices. And here's what happened to that bill. California Governor Jerry Brown, a Democrat, returned it. He wrote, "To the members of the California State Senate, I am returning Senate Bill 1434 without my signature. The bill would require a search warrant before law enforcement officers can obtain location information generated by a cell phone, tablet computer, automobile navigation system, or other electronic device. It may be that legislative action is needed to keep the law current in our rapidly evolving electronic age, but I am not convinced that this bill strikes the right balance between the operational needs of law enforcement and individual expectations of privacy. Sincerely, Edmund G. Brown, Jr., Governor Jerry Brown." For more about this, I was joined by Declan McCullough, the chief political correspondent for CNET. Now, we first talked about his coverage of the Obama administration telling federal judges in New Orleans yesterday that warrantless tracking of mobile devices is perfectly legal.
Well, I've been listening to the audio. I wasn't there for the oral arguments, unfortunately, but the audio is up online, and the judges seemed like they didn't really understand the technology that well, but they understand the procedure and the principles pretty well. So I suspect that they're going to take a pretty critical view of the government's arguments in this case. It's too early to know. We'll have a decision in a few months.
I know, Declan, you wrote that records kept by wireless carriers can hint at or reveal things like medical treatments, political associations, religious convictions, even whether someone's cheating on his or her spouse. So talk a little bit about, privacy aspects of what is being sort of brought up and discussed in court.
Well, marketers love cell phone location information. App makers, people making iOS or Android apps do, and the government does as well, because you keep this is a device that you keep with you if you're like a lot of people all the time. Millions of people just carry it in their pockets or purses. And so and whenever it's in use, even if it's turned on and not making a cell phone call, it's talking to the cell phone networks, and so it can route calls properly. So if you look back at the logs, they're very detailed, and they show minute by minute, hour by hour movements over a long period of time. And so you can stitch together what someone's doing if you have access to these logs.
And you mentioned, marketers loving, mobile devices. Sometimes, Declan, I'll be honest, I've got my iPhone, and sometimes I like to ask Siri, hey, Siri, I'm in the mood for Italian. Where can I go? Or is there sushi where I am? And, she figures out where I am and gives me back some responses. Always gives me good recommendations. But I think what a lot of people don't understand is that it's not just about, Googling, where the nearest department store or restaurant is. It's not about talking to Siri. That marketers, or not marketers so much, but that the government, it does have the ability to see where people are anytime.
Right. And it's... If Siri knows where you are, that means Apple's servers, probably somewhere in Cupertino, California, know where you are. And that means that the government can figure out where you are as well if they have access to those servers. And so, look, I mean, nobody's saying, not even the ACLU, the Electronic Frontier Foundation, the civil liberties groups that are part of this case, they're not saying the government should never have access to it. The issue here is under what circumstances they can have access to this location information. And the groups are saying, look, we have a Fourth Amendment to the U.S. Constitution. It says get a search warrant, go to a judge, demonstrate probable cause. This is hundreds of years old. This language is from the Bill of Rights enacted over 200 years ago. You know how to do it. Just do that, and then you can get the data. And the government has said, and this is both a Bush and Obama thing, it's bipartisan under the DOJ, that's too high a burden. It'll make investigations more difficult. We want to be able to get it without having to go through the warrant process.
Yeah, I mean, is the warrant process that difficult? I mean, obviously, if there's a kidnapped child or a missing person, that getting a warrant should be pretty easy and pretty fast, right?
And in reality, you have exemptions for emergency disclosure. I mean, sometimes it's like 48 hours, 72 hours. They can do it without a warrant. If a kid's life is in danger, Facebook is going to turn over the data. AT&T is going to turn over the data without a warrant. We're talking about non-emergency, non-life-threatening routine investigations. And the DOJ says we just want to be able to argue it's relevant to an investigation as opposed to probable cause, something that's actually more privacy protective. And so. And this is also what the federal legislation is proposing. There have been a bunch of bills introduced, most recently last week by Representative Lofgren, who represents a Democrat who represents the district in Silicon Valley that's headquarters to a bunch of these companies, including Google. And she says, and the bill says, it hasn't gone anywhere yet, but it says search warrant required for location data.
Let's talk now about what went down in California. The governor siding in this case with law enforcement over privacy issues. I was asking you this before, but I mean, is it that difficult for law enforcement to get a warrant? And talk a little bit about California and what this means.
Well, at the risk of sounding slightly legally geeky, the standard is whether you can demonstrate probable cause before a judge versus which is a relatively high standard that's more privacy protective versus just relevant to an ongoing criminal investigation. Well, you know, a lot of stuff's relevant to an ongoing criminal investigation. And we've seen over time that broad surveillance powers can be abused. The Department of Justice Inspector General has come out with a bunch of reports. But moving on to California, what happened is that the ACLU and some other privacy groups wrote a bill that really wasn't worded that well. I like the idea behind the bill. You can see where they're going. But actually, it wasn't just law enforcement that objected. It was also the cellular industry. I wrote an article for CNET in June, I think it was, saying here are the objections they're raising. It didn't understand the technology well enough. So I think it was a combination of industry and law enforcement opposition that persuaded Governor Brown to say, nah, better luck next time.
So what are the objections by some of these mobile carriers? Why would they object to this language?
They think it's poorly written. I don't think I have to go back to my article 4 months ago, but I think they raised things like civil penalties. They didn't like some of the emergency exemptions, saying that they weren't broad enough to actually let them respond in the case of emergencies. I think that Brown can be convinced to sign a bill, but this was kind of moving quickly, and it didn't have this type of hearing and legislative record that you probably want. So next time, better luck next time.
It's interesting to me, Declan, how much of this is unsettled at this point. I mean, I know that CNET disclosed the Justice Department's warrantless tracking requests from back in 2005. Why, 7 years later, are there still not clear lines drawn here?
Well, in part, I mean, and in fact, it was my CNET article. Thanks for mentioning it. That was the first to disclose this. This was, as you say, 7 years ago. I think it was over 7 years ago now. It's a combination of a few factors. The first is that 7 years ago, this was pre-iPhone, right? This was before people relied on these devices as much as they do now. Because it's not just cell phones we're talking about. It's also, we've got like an Android pad or Kindle, depending on the model, or an iPad 3G or something that's talking to the carriers on the networks. This can be tracked as well. So it's a combination of technology. It hasn't advanced until relatively recently, and Congress is kind of slow moving at once law enforcement, and including the Department of Justice, says no, this is going to hinder criminal investigations. Well, we fought this in the 1990s during the encryption wars, and it's going to take a while to fight this one again.
Just real briefly, Declan, lay out for me some of the top 1 or 2 arguments by organizations like the EFF and the ACLU in terms of why this needs to stop right now.
They have the technological argument, which is that this is a vast amount of data. One order can allow the government to get megabytes, gigabytes of it. And the second is the constitutional argument. The Fourth Amendment protects Americans' privacy, including your location privacy, and there's a Supreme Court decision dealing with GPS physical tracking bugs earlier this year that they think is relevant.
All right, pretty interesting stuff here. Declan McCullough, Chief Political Correspondent for CNET. Thanks for weighing in.